rulings and orders, which should be journalized by now. As far as I know, the court does not have a journal entry of judgment and decree of divorce submitted as of this point. I also note that Mr. Wood has moved to withdraw his counsel for the petitioner in this case, which has actually been objected to by the opposing party. So I'm going to start with Ms. Schuyler and ask her, where are we at on this case?
Thank you, Your Honor. So did you receive my exhibits?
I did.
Okay. So I did draft a journal entry. The proposed journal entry is Exhibit A. I did supply the email that I sent the journal entry, showing that I sent the journal entry to counsel Mr. Wood. I sent that on Tuesday, May 13th. As you stated, we did have trial on May 7th. I did supply as well, which is reflected in the court filing, Exhibit C, which is Mr. Wood's objections. If you look at the objections, Your Honor, unfortunately, a majority of them are not actual legal objections. They are essentially requests to change your ruling. And I can go into further detail, but I would argue 80% of them are just requests to change your ruling. They're not actual legal objections. And I think that's where we're at a standstill. I was waiting on this hearing.
What about the other 20%?
I did make
corrections that are appropriate?
I did make them.
Okay.
So specifically objection 1, 3, 7, 17, and partially 14 were all made. Missing a comma or referencing specifically the parties for joint legal custody. I did make those. But outside of that, the others are requests to modify your ruling. So I was waiting on this hearing to file a motion to settle the journal entry. So that's where we're at on the journal entry.
All right, Mr. Wood, as far as the court's concerned, the court wants to settle this journal entry before allowing you to withdraw. I do understand the nature of your motion in this case, but I do note that on behalf of your client, you filed certain objections back on June 3 to the wording of the proposed journal entry of judgment and decree of divorce. Some of these cosmetic changes have been made, apparently. I understand that your client may not be 100% in agreement with the court's ultimate rulings in the case, but what this journal entry is intended to do is to simply document what the court did rule upon. So what's the problem here, Mr. Wood?
Well, Your Honor, I received from my client approximately 4 pages of changes that he wanted to make in the journal entry. I took those at the best I could and made those objections known to the court the best I could that would not be considered frivolous or completely not allowed in this type of a review of the journal entry. So I did what I could. And then once I did that, then...
Welcome back, Legends of Justice. Today's case is one of those courtroom roller coasters where everything that could go wrong does go wrong. Except this time, it's all self-inflicted. Meet Antonio Perez Beal, our self-proclaimed legal expert, who believes he knows more than his 46-year veteran attorney and even tries to take on the judge. On the other side, we've got Sydney, his ex, who just wants to move forward, while her lawyer keeps things tight and professional. What follows is a clash of egos, accusations of incompetence, disciplinary threats, and a judge who has absolutely zero patience for nonsense. Stick around, because you're about to see how quickly firing your lawyer and going solo turns into a masterclass in self-destruction. And trust me, the judge's facial expressions alone are worth the price of admission.
I received wording from my client that he was did not approve of what I have objected to and wanted to know why I didn't use everything that he'd given to me as objections in the journal entry. So I did what I could to pare it down. What really concerned me, though, also is that I filed that on June 3rd, but on his what he had sent back to me, objecting to what I'd sent, he'd started sending copies of that to the disciplinary administrator. And so that concerned me whenever the disciplinary administrator gets involved and indicates that, you know, she didn't want to be involved with that. So I understand the court's position on withdrawing, but I had to put forth the objections that my client in some manner objected to with the understanding that I think some of his objections really would be more of a motions for rehearing or motion for modification. And that's a little bit of a problem when people are using the internet or whatever they're using to come up with attempting to practice law. And so they don't understand the distinctions between those and the objections to the journal entry. You know, the journal entry is supposed to recite what this court had ordered. And it's not to be the objections to what the court had or whether you agreed or disagreed with what the court ordered. The journal entry is to reflect what the judge ordered. And whenever I get something saying, no, these are all the objections I have to the journal entry, and I'm sending these copies of all this to a disciplinary administrator, that concerns me that I've got someone, watching over my shoulder.
Here's where Antonio's strategy starts to unravel. Instead of accepting the judge's prior rulings, he's basically trying to relitigate the entire divorce through wordsmithing. He's nitpicking commas and phrasing, hoping it somehow changes custody dynamics. It's like arguing with your teacher over spelling, thinking it'll get you an A. Judges hate this tactic because journal entries aren't do-overs. They're simply the record of what's already been ruled. And when you mix in someone desperate, emotional, and determined to bend reality, you've got a recipe for disaster. Question for you guys. Do you think he's genuinely confused about legal procedure, or just stalling because he doesn't like the out?
If he and I cannot communicate, if he continues to think that I'm not doing a job for him, then I just figured I had to withdraw, Your Honor.
All right. Ms. Schooner, I'm going to go back to you for a moment. I trust that there's been some personal communication between you and Mr. Wood in an attempt to try to reconcile differences on the wording of the journal entry, perhaps a recent phone conversation or email chain or something?
I did call Mr. Wood. I did let him know I was going to have to object because we were still in the process of working out this journal entry. You did order for some documentation to be provided to me by petitioner in regards to picking a vehicle. So I said, hey, get me that. We did not go into the journal entry as much. I did let him know, hey, I made some of the cosmetic corrections, but your objections or your client's objections are, again, more so for reconsideration, and I'm not going to make those changes. And that was after our Exhibit D, the email, including me and Mr. Wood.
This is where Antonio's male Karen energy hits maximum volume. Not only does he disagree with his own lawyer, he escalates it to the disciplinary board, essentially tattling because things didn't go his way. Imagine hiring a mechanic, then reporting them to the state board because your car isn't faster than a Ferrari. That's what's happening here. His attorney even says, "Look, I have 46 years of experience. I know what I'm doing." But Antonio thinks his few Google searches make him a courtroom savant. And honestly, the attorney's frustration is showing. He's ready to tap out before this client drags him down with him.
The disciplinary administrator, where Mr. Presbill says he is going to file an ethics complaint against me. So not as much as I'm sure the court would prefer, but obviously with this email coming out, I believe Mr. Wood was trying to be as cautious as he could due to the situation.
All right. So the first issue before the court is settlement of the wording of the journal entry in this case. And in doing so, I'm going to try to systematically go through here and determine is there a legitimate objection to the wording used by Ms. Schooler in what I see as, and I want to make sure everyone's on the same page as to what I'm referring to. In my exhibit notebook, it's Exhibit A, which is what I believe is Ms. Schooler's most recent attempt to draft an appropriate journal entry of judgment and decree of divorce. Is that correct?
Yes, it is, Your Honor.
All right. Obviously, the comma in number 1 has been resolved. Petitioner objects to the court's finding, and the petitioner will not respect the bond of the respondent. Oh, to the extent, apparently, that the petitioner will not respect the bond of the respondent in this matter. If that's consistent with a ruling from the bench, and I think it is, then
Your
that's not
Honor,
objectionable.
may I make a statement?
Mr. Perez-Beal?
Yes, sir.
So
That's me.
What's your statement?
My concern here is several things in the journal entry are not written how the court ordered. I have recently filed for a transcript request for the judgment in this case. I've paid for that and I have a receipt for it. And a lot of the wording affects the legality of the court's judgment. And when it comes to getting involved with disciplinary administrator, I done that because Mr. Woods failed to address our son getting bit by a dog while in his mother's care, failed to address Sydney not showing up for
Okay, we're
exchanges
getting
of
off the
court
path
order
here.
twice.
We're
No,
getting,
sir, we're not.
okay. All right, regarding number 2, the court will overrule any objection to this finding. Mr. Simon's actions in, as I recall, taking possession of the child at a bus stop, that alone gives this court pause.
46 years of experience versus 46 minutes of Google Law School is the heart of this case. It's not just funny, it's tragic. Because so many people in these situations think self-representation equals power, when in reality, it's like walking into a chess match after watching one YouTube tutorial. The attorney knows the difference between objections, motions for reconsideration, and journal entries. Antonio, he just wants the words rewritten to fit his version of events. It's a classic case of pride versus professionalism. And guess who's going to win? Spoiler, it's not Google Law School.
And some reason to make a finding that the court has concern that Mr. Perez-Beal will not respect the bond of this child with his mother.
That was during my
And there are other
parenting
reasons.
time.
However, the court finds that the objection is overruled as to number 2. Number 3 apparently has been corrected. As the court recalls, there was a protection from abuse case previously between these parties. The court finds that even though Mr. Perez-Beal may deny that there was ever any abuse by him, court does find that that's an appropriate finding for the court to make. And the court will
Point of
overrule the
order.
objection to number 4. The court also finds that there has been difficulty between these parties based on the evidence to effectively communicate regarding setting a parenting plan or deciding many important matters concerning this child. So the court does
I'm
find that there's
submitting all of
evidence
our
in the
text
record.
messages.
All right, if you interrupt one more time, Mr. Perez-Beal, we're going to mute you or take you out of the...
Now we've officially entered nuclear meltdown territory. Antonio isn't just coming after his own lawyer. Now he's threatening ethics complaints against opposing counsel too. That's like losing a game of Monopoly and then trying to sue the banker. It screams desperation. And here's the thing. Once you weaponize disciplinary boards for petty grievances, judges notice. They see it as a stall tactic, a way of bullying the process. And if a judge starts to think you're abusing the system, you can kiss your credibility goodbye. Audience question. If you were Antonio's lawyer, would you tough it out? Or run for the exit like this guy is trying?
Number 5. Objection number 6. Objecting to paragraph 13 in the school district should be USD 232.
Your Honor, just so you don't have to pull up Google it, USD 232 is DeSoto, Kansas. which is up towards Lenexa.
282.
All right, so number 13.
A lot
West
of the
Elk Schools,
objections-
why is that a problem? There's
A lot of the objections he made are not what I requested, and I'm getting ready to submit that,
All right.
what I have requested to him.
Okay, I think the children do attend West Elk schools, correct?
Yes.
They
Yes,
do,
sir.
Your Honor.
Okay, so what's improper about 13? I
He
don't
has
see any
manipulated
problem
my
there.
objection request.
Okay. I don't think we need to put the USD number in there. I think the term West Elk Schools is specific enough. I'll overrule any objection to 13.
This is what happens when you let emotion hijack legal proceedings. Antonio is told to stick to the journal entry, but instead he launches into stories about dog bites, missed visits, and anything else he thinks will paint his ex as the villain. Now, those might be serious issues, but this is not the time or place. This hearing is specifically about the wording